There was one historic shift by the court that seems to relate to this point. In 1898, in Plessy-Ferguson, the court held that separate could be equal in interstate transportation. Yet in 1954, in Brown versus the School Board, it held that separate could not be equal in school education. Now, the law hadn't changed. What appears to have changed is the judge's opinion of how the law should be interpreted. In other words, did they not relate to the temper of the times?
The judges had changed. That's right. The judges had changed. As far as my opinion is concerned, my agreement to that case, I would have agreed to it in Plessy and Ferguson. I would have agreed to it at the time those amendments were first adopted. And that's my view, was that we had a simple question. Does that give to the colored people of the nation equal protection of the law? Now that means, well, they're being treated any better because you gave them different schools and separated them. And if so, was it, as those Civil War amendments provided, given on account of race? Well, I've lived in the South all my life, practically, until I came up here. And of course, I knew what it was. I didn't need any philosophy or any changing times to convince me that that was a denial of equal protection of the law. And I never, for one moment, based my decision on anything except I thought it was a denial of equal protection of the law then, had been in the past, and will be in the future.